My name is Marcos Lopez Bonilla. I'm a corporate attorney at EPGD Business Law. My focus is on banking, regulatory, and financial services advisory, but I also do corporate work as my main focus. I wouldn't be able to speak directly to trade, but a lot of the corporate work is, at least in my firm, is focused on single sole proprietorship, small business owners on, you would say, the Florida landscape. And then on the depository institution side, I worked a lot with Latin American banks, so anywhere from South America, Ecuador, Colombia, and then you see a lot in Guatemala, Honduras, Central America. A lot of them have to do with remittance businesses, money services businesses, as well as establishing branches and mostly a presence here in the United States so they can, branch out and open into the U.S. markets. Quite frankly, I wouldn't say that I've seen a specific concern, but it's mostly about navigating the financial markets in the United States and the regulatory markets. And obviously, to the extent there are concerns, it's mostly about how foreign entities will be viewed. But I would say that if anything, there's been a reduction in activity as a result of the new regime, the election. But I would say that to the extent that they have particular questions, it's mostly about navigating the legal framework. Well, I'll give you a specific example, and I'm actually working on a blog post about this. So I deal with OFAC sanctions. Partly, what I've seen is that there's a difference between how the treatment of, say, a foreign terrorist organization, a FTO, is treated versus like an OFAC sanctioned party. Like there are enhanced, I would say, liabilities to an FTO. So you could see criminal proceedings, and so like with respect to Latin American parties, let's say a party in Mexico is potentially transacting with an FTO, you could see that party potentially suffer some criminal proceedings, or if they were to come to the United States. So there's an added risk, and that will, in practice, what that results in is in enhanced compliance as far as like who they're onboarding, who they're interacting with. Like, are their due diligence proceedings up to date, and are they capturing all the information necessary to make sure that the person that they're transacting with isn't such a party? So I would say that was a recent decision by the administration. So that is a good example of a change that they've suffered in recent months. Honestly, I like the discussion related to AI. I think it's a very important tool. I think that perhaps this is a tendency of the legal industry. We're kind of slow to adopt new measures, and I think that this delay could result in bad results for the legal industry. So my main takeaway is being adaptable, being able to incorporate this into your proceedings, into the way you manage your law firm. And in many ways, this actually enhances how you can serve a client, because if you can create a tool, if you have the savvy and the knowledge, and create a tool that incorporates a lot of your legal knowledge and is able to feed that into the client to where they can answer these questions, I think that while there is a risk to the legal industry itself and to legal professionals potentially, it creates an opportunity for new findings, essentially a new way to consult with clients and to address their concerns. So I think that final discussion on AI was very, very pertinent. My message would be to not be afraid of change, but to be wary of it, and wary in the sense of be proactive. Like, I don't think that we live in a world where slow-moving parts can eventually catch up. I think that things are speeding up as they develop, and if your compliance programs, if your internal controls don't adjust to the changing times, if you assume that everything is business as, you could be negatively affected by the changing tides, essentially.